Good morning, everybody. Today is January 22nd, and this is our first recorded live chat for restorative justice at Remington College, course code OCJ4661. My name is Lance Spivey. I'm your instructor for the next 5 weeks of this course, and I want to take this time to just basically introduce myself to you. Again, my name is Lance Spivey. I am an instructor here at Remington College. I've been teaching at Remington College for about 2 years. I teach a lot of criminal justice courses throughout the United States at various universities and colleges in their online department. I also teach at the Police Academy here in Arizona, and I teach report writing, ethics, and law enforcement services, which is just basically an overview of all the different types of law enforcement services that are offered in Arizona. So basically the police cadets, people going through the academy, know who is working and what agencies they work for in Arizona and their responsibilities. So this chat is going to cover Chapter 1 of The Essentials of Criminal Justice by Larry Siegel. Basically, we're talking about crime and criminal justice. So what I'm going to try to do in this next 20 minutes or so is just provide you an overview from the PowerPoints from the school about crime and criminal justice, and try to interweave some of my professional experience into the lecture. A little bit about my professional experience. I've been a police officer in Arizona for 16 years. During that time, I've worked for a city police agency, a state police agency, and now I currently work for the Apache County Sheriff's Office. With the Apache County Sheriff's Office, I serve as the Investigative Services Division Commander. I'm in charge of the division that is responsible for all criminal investigations, administrative investigations, or internal affairs investigations. The Drug, Gang, and Violent Crime Task Force, property and evidence, recruitment and selection, so I help pick who we're going to hire, training and compliance, and civil process. So I have a wide variety of units assigned to me, and I oversee those units. In my time as a police officer, I've worked patrol, days, nights, weekends, swing shift. I've worked pretty much every specialized type of function there is: traffic enforcement, civil process service. I've even been a field training officer. I've served as a sergeant in the field. I've served as a sergeant in an administrative capacity. I've investigated every type of crime, from simple assaults, thefts, to murder. So I've seen a lot of different things. I've investigated a lot of different crimes. I've experienced a lot of different events throughout my time as a police officer. I was working when September 11th happened, so I remember how it was like to be a police officer immediately following September 11th. So without further ado, let's move into the lecture for the next few minutes and go over Crime and Criminal Justice, Chapter 1 of The Essentials of Criminal Justice by Siegel and Worrell. The criminal justice system is composed of different branches or units or divisions, if you will. There's the law enforcement division, the court division, and correctional agencies. Law enforcement is basically responsible for investigating and upholding the law, providing conflict resolution, community services, and serves as the entry point and starting point for the entire function of the criminal justice system, meaning that until somebody reports a crime, until the police investigate it, until the police make an arrest, nothing happens in regards to criminal law violations very easily. The court tries a case. It is the umpire. It determines and upholds the fundamentals of a fair trial. If the trial is not fair, a person cannot be convicted of a crime under the philosophy of American criminal justice. The correctional agencies, they focus on rehabilitating the offenders that have been sent there after they have been convicted of a crime. They all work together to make sure that justice is realized by the victims, by society, and the rest of the interested parties. These parties are all charged with maintaining order, enforcing the law, identifying transgressors, bringing the guilty to justice, and treating criminal behavior. The police make arrests based upon probable cause. They've identified somebody that was an aggressor or violator of the law, and they use their powers to make an arrest, charge that person with a crime. The prosecutor files formal charges in court, tries them, or offers a plea deal that is justice in a sense. And after that, the penalty is imposed. The offender could be put on probation. The offender could be confined to a community counseling center or a treatment house or treatment rehabilitation program, or they could go to county jail or state prison. It's designed to help rehabilitate them, to identify what is causing them to engage in deviant or criminal behavior, and then come up with some type of plan or program for that offender that helps them rehabilitate, to become a successful member of society and not re-enter or re-engage in deviant behavior. Let's talk about the criminal justice process. The criminal justice process, there are several decision-making points that from the initial investigation or arrest by the police to the eventual release of the offender and his or her reentry into society. A police officer has decisions to make. As a police officer, I develop probable cause for the arrest of somebody. I do not have to physically arrest that person and book them into jail. I can submit charging documents to the prosecutor for review. Those charging documents are referred to as police reports. I can issue a citation. I can issue a summons for them to appear. I do not have to physically take that person to jail in order to exercise my power as a police officer. But I have to make a decision based upon the type of crime that was committed or the facts surrounding the case to determine what is my best course of action. Was it a violent crime? Was it a sexually deviant crime? More than likely, in those instances, somebody's going to be booked into jail because I have a duty as a police officer to protect society and to protect the victim. And if that person engaged in some type of violent crime, like homicide or a violent assault or a rape or sexual assault or molestation, I'm not going to let that person walk around freely in society until the prosecutor decides whether or not to charge that person with a crime. I am going to exercise my powers of arrest and book that person into jail and then submit my report, and that starts a process. Just like I have decisions to make, the prosecutor has decisions to make. The prosecutor is going to look at the entire event, the evidence, the statements, the circumstances, what the police did to determine whether or not they can obtain a conviction, whether or not to take the case to trial, whether or not to offer a plea agreement with less time because there are some issues with the report that might not go favorably for the state or the prosecutor at trial. They have decisions to make too. Then the judge, after the trial's done or somebody accepts a plea agreement, the judge listens to the evidence about the offender and he makes decisions about what type of penalty to impose: probation, treatment, incarceration, or mix. Those are the major stages up until sentencing. After sentencing, corrections gets the offender and looks at the offender's past and screens them, conducts several screenings to determine where this person belongs in the correctional system. Does he belong in a maximum security prison, or does he belong in a minimum security prison? They look at that because they want to help the person rehabilitate. They don't want to make that person institutionalized, meaning that they only know how to survive within the walls of a prison. We want that person in society being successful. So how did the criminal justice system develop today in the United States? We can look at our history. We were founded by settlers from England that left a tyrannical king for the United States. They landed in Plymouth Rock and they set up the first colonies. Then from there, as society grew and developed, we expanded to the West. As society became more populous, we had to do something instead of the informal types of criminal justice systems that we've had in the past and up until that point. We had the watchman system, which was basically a hands-off order maintenance type of system where the watchmen that walked around the community didn't want to get involved in anything. They kept order. That was it. It was up to the parties that were involved in some issue to resolve the problem themselves. As society became more complex and more large and more expansive, we began to develop more styles of policing. We became more hands-on. We became more law and order, follow the law, or make arrests. And that was a result of society's need for justice. We no longer could be watchmen. We no longer could take on a hands-off approach because crime was becoming more prevalent. People were being assaulted. People were being killed. And the Wickersham Commission in 1931 found that policing needed to change along with society. So as society became more complex, more developed, policing needed to evolve with society in order to provide justice. Today, we're in the modern era of justice, and research by the American Bar Foundation during the 1950s found that there was a disjointed system of criminal justice. It was largely hidden from the public scrutiny. After a victim reported a crime, the police came and investigated it and submitted that crime to the prosecutor, and the victim was left completely out of the loop. We didn't need to keep the victim involved. Justice was dispensed of through the courts, and the public really didn't know what happened until way after the fact. This research conducted by the American Bar Foundation found that there was a need to integrate the components of the criminal justice system. The police, the courts, and the corrections system all needed to work together, share information, and develop a better system for the offender, for the community, and most importantly, the victim. We needed to work together to share this information to come up with a true meaning of justice, to provide justice to everyone. The federal government, because of these inadequacies and this realization that the criminal justice system was disconnected from society, the federal government became involved in reforming the criminal justice system. In 1967, President Lyndon Johnson's Crime Commission published The Challenge of Crime in a Free Society. It was a comprehensive report that focused on the criminal justice process in the United States as it was at that time, and then recommended reforms based upon those formal observations by the Crime Commission that President Johnson established. As a result of this findings by the commission, the Congress passed the Safe Streets and Crime Control Act in 1968. And this basically brought federal funding to state and local law enforcement. And part of that funding focused on education and research, how to make the criminal justice system better. This funding and this research was all conducted by the Law Enforcement Assistance Administration. It's a federal government agency that is responsible for helping state and local law enforcement and criminal justice evolve and become more modern and institute change to help make the criminal justice system better. What is contemporary criminal justice? Contemporary criminal justice is society's instrument of social control. The justice system responds to dangerous behavior. Dangerous behavior can be people that engage in different types of crime. Crimes are identifiable dangerous behavior, whether it's substance abuse, whether it's gambling, whether it's burglary or other property crimes. Crimes are generally identifying dangerous behavior. Today, modern contemporary criminal justice focuses on apprehension, adjudication, and sanctioning through the police, courts, and the correctional system. That is our major goal in the criminal justice system: to apprehend offenders, to adjudicate the offender, and then to sanction lawbreakers, to provide justice for the victim and society and even the offender. Criminal justice components or the functions of criminal justice can be found in every branch of government: the executive, the judicial, and the legislative branch. The legislative branch, they're the ones that develop the law and identify criminal acts and define what criminal acts are. The executive, through his powers of veto and approval of laws, can say no. Just because the legislature thinks this is a criminal act doesn't mean that I agree with it and it shouldn't be criminal. So the executive can veto. The executive has the power to appoint heads of the courts, judges. They have the ability to nominate and appoint state police chiefs. Remember, the executive, judicial, and legislative branches of government can be found at every level of government: city councils, city government, county government, boards of supervisors, and at the state government and federal government. So the executive has the ability to appoint people to oversee and administer justice through the three branches of the criminal justice system. Likewise, the judges have the ability to interpret the Constitution to make sure that people and laws are treated equally. There is not an overbearing power of the police. They protect our Constitution. They protect our constitutional rights. They interpret the Constitution based upon the true meaning of the law. What are the principal components of the contemporary criminal justice system as it stands today? It's pretty much the same. There's the police agencies. They're responsible for investigating crime and making arrests. The court, they conduct trials and sentencing offenders and make sure that the constitutional rights of the offender are protected and that there is a fair trial for everyone. Because if it's not a fair trial, the person won't go to jail, they won't get convicted, and their conviction may be overturned on appeal. Correctional agencies, they're responsible for correcting deviant behavior through the incarceration and incapacitation of the offender. They develop programs to help rehabilitate, to provide the offender with training in order to help decrease recidivism. Recidivism is when somebody goes to prison or jail, they're released and they reoffend because sometimes, quite frankly, they don't have the education, they don't have a job skill, or they're addicted to a substance, or they have some other type of addiction that hasn't been addressed And that is the goal of the correctional system, to rehabilitate the offender. How much does it cost the taxpayers, you and me, in order to fund criminal justice in the United States? Roughly $250 billion are spent annually on criminal justice and its components. There are approximately 18,000 local, state, and county law enforcement agencies, and over 1.1 million police officers and civilian employees employed in the police agencies. Of this 1.1 million officers and civilian employees, there are about 120,000 sworn federal law enforcement personnel. There's a special agents of the FBI, the Secret Service, the Department of Justice, the Immigration and Customs Enforcement. Those are federal law enforcement agencies. There are 17,000 courts and 8,000 prosecutorial agencies, roughly. There are 6,000 institutional correctional agencies and more than 3,500 probation and parole departments throughout the United States. The size and cost of American criminal justice is very large. It's one of the largest systems in the world. It's one of the most modern systems in the world. $250 billion seems like a lot of money, but look at how our police, how our courts, and how our correction systems function compared to other third world countries or other undeveloped or industrial countries. The differences are staggering, and the treatment of the victim, the offender, and society are much different in certain countries compared to the United States. So what is the formal process in the criminal justice system in the United States? There's the initial contact. The police come out, they make contact with the victim reports the crime, the police officer takes a report. Then the victim goes and looks for witnesses and the suspect. They conduct their investigation. They conduct their investigation by conducting interviews, gathering evidence, taking notes. They develop probable cause. They make an arrest. Like I talked about, they can arrest the person and book them into jail. They can issue a summons or citation. They make the arrest. Once their investigation is complete, they've identified the suspect, they've developed probable cause for that arrest. So they make the arrest. That person is in custody. They go to jail. They see the judge. The judge sets a bond, or they could release them on their own recognizance with release conditions. After the initial appearance, the prosecutor will file formal charges within a certain amount of time after the initial appearance. In Arizona, that's 48 hours. So the prosecutor gets to report after this person's been initialed or had their initial appearance in court. And the prosecutor looks, okay, there is truly probable cause that this crime occurred. The evidence is overwhelming. There is a likelihood of conviction. The prosecutor will then file formal charges with the court. The prosecutor may say, no, there's not probable cause, and then decide to decline prosecution. Then that person is released at that point. Preliminary hearing and grand jury is the next step when the prosecutor decides that there is probable cause that the person committed this crime. Preliminary hearing is merely that. It's a hearing between the prosecutor, the defense, the prosecutor's witnesses, the defense witnesses, and the judge. The judge finds whether or not there's probable cause that an act occurred and that it was a criminal act. And if that happens, the charging document is moved on to district court or superior court in the form of an information. That is the formal document, the formal charging document that is moved after the probable cause hearing. In the grand jury, it's a jury. There is no probable cause hearing conducted with a judge and the defense attorney. In the grand jury, the prosecutor presents the evidence to the grand jury. The grand jury is composed of 17 members of the jury in Arizona. And they look at the information. They hear the evidence from the police officer, the testimony from the police officer, and other witnesses that the prosecutor calls. The defense is not there. The judge is not there. The grand jury meeting is transcribed by a court reporter, and they determine, the grand jury, whether or not there is probable cause. If there is, they indict, and it's a true bill. And that goes on to Superior Court or District Court for the remainder of the next few steps. Arraignment is where the true bill or the information is read to the defendant, stating, these are your charges. How do you plead? Guilty, not guilty? I'm not going to contest it, nolo contendere. And then the next step happens. They have a bail hearing. They determine if the person's going to be released OR at that time, or if they can be released if bail's posted, or they're going to be held without bail. Plea bargaining is where the prosecutor and the defense, they get together, they have a meeting, and they try to come up with a deal that this offender would take if the evidence supports the conviction. If there's not evidence to support the conviction, they're not going to have a plea agreement. It will go to trial. Trial and adjudication, it's where the state presents its case, and they have to prove beyond a reasonable doubt that the defendant committed the crimes charged therein in the true bill or the indictment. Appeals happen after somebody's sentenced. Sentencing is where the defendant is sentenced for their crime. The judge looks at aggravating and mitigating factors and comes up with a sentence. Then after the sentencing, the person goes to corrections, and they serve their term of confinement, and hopefully they're getting treatment. So that's basically the overall formal criminal justice process. So to me, the criminal justice process is like an assembly line. Think of it as building a car or something. Something can't happen without something happening before it. So that every case starts out the same way at the beginning of the assembly line with the initial contact. And it moves through each stage that we went through just a minute ago. And if something doesn't happen, the next step can't happen. If there's not probable cause, the person won't go to trial. Plea bargaining won't happen. So remember, it's like a stepping stone. One step in the criminal justice process can't happen without something happening before it. For example, a person can't have an initial appearance if they're not arrested or a suspect's not identified. That'll never happen. There is an endless supply of cases. Policing will always be in society. There will always be some form of criminal justice. How it evolves and changes 30 or 40 years down the road, that's for you guys. I'll be retired and I won't be a police officer anymore. In my 16 years as a police officer, I have seen how the criminal justice system has evolved and changed with society and society's viewpoint of what justice is. It's a fascinating career. Restorative justice is an interesting topic where we're starting to look more at rehabilitation instead of just incarceration. Over the next 4 weeks, we're going to go through a lot of different concepts about restorative justice, and I can't wait for those discussions to happen. If you have any questions, feel free to reach out to me. Send me an email, send me a phone call, a text message, whatever. We'll talk. I love talking to my students. And with that, I am going to wrap up chat for today. I look forward to our time together again, and best of luck. And if you have questions, always reach out to me. I'm more than willing to help.